What's up, everybody, and welcome in to a discussion on the beginning of Sarah Boone's trial. We're going to talk about jury selection. We're going to talk about the motions hearing. We're going to talk about the snacks Sarah Boone is asking for, what this kind of shows us about her relationship with her attorney currently, and how we can expect it to go and potentially change throughout the entire trial. I'm going to answer your questions, and I'm going to talk about some of the very big decisions that were made in the motions hearing that just concluded a couple hours ago today. So to get through some of the initial conduct and questions and things that have happened prior to the motion hearing, I'm going to run through them kind of quickly, answer any questions you have on them before we actually get into that motion hearing. But the way jury selection has gone is what I expect from jury selection. If you listen to my video yesterday on Delphi, it was very different. Not how I'm used to going through jury selection, not what I'm used to picking a jury, picking it incredibly fast in a high profile case with a lot of jurors. But in this case, it's going more on how you'd expect. High profile case, lots of jurors available, which by the way, we don't always have it. If I asked for 100 jurors on my normal case, a judge would be like, no, you don't get 100 jurors. You can have 35 or 50 or maybe two panels of 30, but you don't just get hundreds of jurors because you ask for it. Well, in this case, you do because of the high profile nature, and it's necessary because a lot of people have heard about this case. So what are they doing? They're going through the first couple of days, striking everybody that's got hardships. Either, they don't read or write the language, don't understand the language, or their age, or some medical issue, or they have some pre-planned, prepaid vacation, whatever it may be. Let all them go. We know it's going to be a couple weeks of trial, 2.5, 3 weeks of trial. So let them go, not deal with those. Also, people that can't follow the law. People that say, I convict everybody or I convict nobody. People that say, I hate cops, I don't believe them, or I believe everything cops say no matter what. I can't scrutinize a witness. I can't sit in judgment of other people. All those people are going to be struck. Get rid of them quickly so we don't have to waste a lot of time. Additionally, in this case, people that have already seen too much or know too much about the case, which there were some that have already made up their mind about the case. We got to get rid of them quick. So we did all of that, and we got to a panel of, I think it's 50 jurors that don't have any hardships, don't have any cause strikes. These are all 50 jurors that we're going to pick from. And now we start the actual voir dire where the lawyers can talk to the jurors. They can ask them questions. They can see which ones they want to strike, which ones they don't. It doesn't mean more cause challenges might not come up, because as jurors continue to answer more questions, might be like, Judge, now that we have this answer from this person, or something's come up that's a hardship, we're going to strike this juror. That can still happen. No guarantees there. But this is when they're going to start to use their preemptory challenges. I would expect them to have a jury by tomorrow. And then I don't know if they're going to do opening statements tomorrow afternoon or maybe on Friday. I'm pretty sure Delphi is doing opening statements on Friday. Now, I appreciate so much all the happy birthday comments. I see them rolling through the chat. I appreciate you guys. Hit the like button. That's the present I want for my birthday. Or subscribe to our page if you guys have not subscribed already. Because I would love to have you join us throughout this trial and hit the alert or reminder bell so you don't miss any of the videos we do on this trial. But then we'll talk just for a second about the snacks, the peppermints, the potato chips, whatever it is that Sarah Boone's asking for. It's not unusual for criminal defendants to ask for stuff like this. What is unusual sometimes is for the lawyer to bring it to the judge's attention. There's only so much a judge can do. And to ask a judge to do this, they're going to have to go check with the jail. They're going to have to check with other people because the judge can't wave a magic wand and make this happen. If her rights are being violated, because we have heard about her not getting back into her cell till 9:30, waking her up at 2 a.m., that's not appropriate. She needs to be getting better sleep. She needs to be able to eat, things like that. But from her perspective, not having proper nutrition, blood sugar issues, whatever it may be, that is something that she can bring up. That is something that your lawyer can ask somebody at the jail about, and even potentially ask it to the judge. Usually we try not to be the first, try to be the last person that does that for her, not the first person that does that for her, right? In this case, it seems like she is the boss in the relationship, is what it feels like to me. And I don't really think I'm going to blame James Owens for that at this point, because you don't want to start a fight with her now. It's not going to end well for you. So you get off the case, or you try to, or the judge forces you to, and it's just a horrible experience altogether. You don't want to deal with that. So you just pacify, you do your job, you represent her your best, you stand for the Constitution, you're a big fan of justice. So I just hope That's what he's doing. That's what he's fighting for. And that's what he really cares about. And some of the annoying things or frustrating things that she may do or ask to be done, you've got to draw the line somewhere. But if it's not a big deal and it's not unethical or immoral in any way, and you can just placate her by asking the judge, hey, judge, can she have some peppermints? Then I don't see a major problem with doing that. We'll see how it continues to go. All reports inside the courtroom is that she doesn't stop talking. That can be very distracting when you're trying the case. And see if you notice a transition in the future of writing things down. I would give my client a pen and paper and say, write down all the questions you have, write down all the comments, point to them. I will look at them. I will read them, but I'm listening to this person. I'm listening to the judge, the witness, the lawyer. I'm reading a deposition at the same time to see if they're answering inconsistently. I'm preparing my cross-examination. I'm looking at the exhibits that they're entering. So I can't have somebody else saying things like, that's wrong. That's not true. Ask this question all the time. If you have specific questions you want me to ask, write them on a different piece of paper and give them to me before I go across. I'll ask some, but not others. So that will really be part of the transition you may see happen in this case, is more note writing and less talking to her lawyers. That's something I would propose potentially. All right. I think that's it. Let me see. Hey, Peter, thank you for explaining in layman's terms for me what it all means. I have a TBI and I'm so interested, but don't understand big words. Happy birthday. You rock. Much love from Liverpool. Well, Dreamcatcher, I'm glad you're here. And I hope that the way I explain things, everybody of all ages and any types of issues you may have, or any competency level or whatever it is, whatever your background, educational, different country, can understand how our system works a little bit better. That's what we have to do to jurors, because anybody can come in and be a juror potentially, and you've got to be able to explain it in ways that they can understand. Chris K, happy birthday, Peter. Did you go into the office today? I did not. If not, according to Amazon, check with Caitlin. Okay, yes, Caitlin is our receptionist, so I will have to check with her tomorrow when I'm in. All right, I am going to get to the hearing now. Okay, so this is a motions hearing, mostly dealing with motions in limine, but also dealing with objections to evidence and exhibits, and some other issues that have come up. So the first part is the motion in limine, where the state has filed the motion that we read together, that the defense should not be able to argue battered spouse syndrome because she argues accident. There's no overt act. It's not a self-defense case. They don't even lay the predicate. This is like a motion for summary judgment. Even if we take everything Sarah Boone said as true, she still would not have enough to argue battered spouse syndrome, self-defense. So he basically repeated everything we already read in the motion, but the defense responds, and it's not Mr. Owens, it's Mr. Henderson, I think his name is, one of Sarah Boone's other attorneys. And he starts making some arguments about how there is an overt act, but the defense should not have to show their hand prior to trial. And this is just some way for the state to try to force the defense to show their hand, because there is an overt act. There was an overt act. It's in evidence. It came out in the depositions. So it's like, oh, this big bombshell is coming. The overt act, what is it? Because the state said there isn't one. The judge obviously hasn't seen one at this point. So what is it? And we're going to play some of the back and forth between the defense, the judge, some of the state's rebuttal, and eventually the judge's ruling on this specific issue, which is, can the defense argue battered spouse, and when can they argue it? If the answer is yes from the judge, when can they argue it, and can they talk about it during voir dire? Because that's why we're handling these motions before the individual questioning by the lawyers. Can they talk about it in voir dire? Can they talk about it in opening? Can they argue it during the state's case in chief? And then, of course, can they put on a battered spouse defense with an expert? And we get that answer during this hearing. So let's take a listen together.
Defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
Yes, but this is the problem that I'm having here. Self-defense is a defense. It's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act?
So we need an overt act in order for there to be self-defense, because there's got to be some reason that she's in fear of serious bodily harm or death. There's got to be something that happens. It can't just be like, oh, you know, back in the day, he said something mean. We know all of that. And the state asked certain questions that tracked with the statute, and she couldn't necessarily come up with an answer according to the judge's reading of the deposition. Obviously, I haven't read the depositions. So the defense has to provide what that overt act is. But I do agree from the defense's perspective that, Judge, it's our argument to make. So if an overt act comes out at trial, we're allowed to argue it, and we're allowed to present evidence during cross-examination and during our case in chief, during opening statement, during closing argument. So let us do our job. Why are you making us make that argument now? And while I don't disagree with the defense, the judge is basically forcing their hand. So once he does, you've got to let the cat out of the bag and explain your argument. Explain yourself.
By the victim, which would have given rise to self-defense. Because the case law, taking aside the state's case law under the standard ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial standard ground motions. So I find those cases distinguishable for that very reason. But there's specific
So
cases.
what he's saying is there are certain cases the state cited in their motion that don't necessarily apply because that's stand your ground. It's very different at trial. It's a much lower bar to be able to argue self-defense at trial, which it should be, but there still needs to be something you were defending. You can't just be the complete aggressor and then claim self-defense. You can't say everything's great, we're at a birthday party, we're loving, we're kissing each other, and then I end somebody's life and that's self-defense. So it's a balancing act that the judge is trying to see, is there even anything there, even with the facts and the light most favorable to the non-moving party, which would be the defense here.
So bless you. There's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but
What
that
is it?
has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a
He doesn't want to say it. It's clear the defense attorney does not want to say it, but he's going to have to.
determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing.
Even just something small, just something as small as, your pinky finger, a scintilla of evidence. How small is a scintilla? That's important once we get to what the actual overt act is.
With the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only
Everybody's in agreement here. And again, I think this is the defense attorney trying to make every argument he can before disclosing what the overt act is.
witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment.
So, and one of the things is, so there's a bit of trust in the legal system. You can make arguments. You have a good faith basis and belief and reasonable belief are going to come out at trial. You don't always have to say exactly what it is, But there has to be a reasonable basis. And it seems like at this point, the judge doesn't think or thinks there might not be a good faith basis to even make a self-defense claim. So he's going to basically force the defense to tell him, what is your reasonable belief? What is your good faith basis to even believe this is self-defense? Because I'm not seeing it, is what what it feels like is coming from the judge.
Anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there.
And that is a shot taken by the state, but the defense said he wasn't there. And it kind of sounded like the defense attorney didn't read the depositions, but the state definitely took a shot there. Like, judge, seems like he didn't even read the depos. So I'm arguing with somebody that doesn't even know the factual basis that's been proffered in this case. But the defense is also right. And it's like, judge, we're telling you evidence is going to come out of an overt act. We're telling you this is a self-defense case. We should be able to argue that.
But the court has before it the statements that Sarah Boone made when directly asked.
He has the statement Sarah Boone made to her mental health professionals in a deposition of those mental health professionals, not what she's going to testify to on the stand necessarily. So while there is some gray area, and the judge makes basically the only ruling he could make at the end of this.
What happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy.
So this is an analogy he's about to give, comparing Mr. Torres to a dog that I think is like, falls completely flat. I don't think it did its job at all. You guys let me know if you disagree in the chat. I don't know why he didn't just stick with a human analogy, that if a human does this, you can't do this to a human. Bringing the dog part of it was just kind of a weird brain space that I got into, but he makes this analogy, and you can watch Judge Kranek. I don't think it affects Judge Kranek at all.
Somebody owns a bad dog, and that bad dog bites, and that bad dog is bitten in the past. But on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works, with or without battery.
That makes no sense. I think that's not a good analogy personally. I think you just use, if your boyfriend has punched you in the past and he's in the suitcase and he's begging to get out, you can't just say because he's punched you in the past, it's self-defense and now I'm going to leave him in there. I mean, that's what I'm thinking, is like, just use the actual analogy we have in this case. It works better than the dog analogy.
Spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case.
So his terminology right there, you can't make up a fictitious act of violence. So here's where I'm going to disagree with. I agree with him and I disagree with him. I obviously agree with him that you can't make up a fictitious act of violence. You can't actually make up a fake act and say, oh, this is great. You shouldn't lie, right? That's not how this should work. But by prosecutors' definitions, that happens all the time. It just happened in the Ashley Benefield case. Prosecutors argued she made up that overt act. She made up the part that Doug Benefield was the aggressor. And they can say the same thing they want to about Sarah Boone, that she's going to make up some event that's an overt act. But the point is, if she says there is one, it's up to the jury to judge her credibility. But I think the better argument that the state has been making most of this time is, even if we listen to everything she has made up, Judge, all the fictitious facts that she's made up, she still doesn't have an overt act. I think that's what he's trying to say. Because saying that defendants can't make something up, it's like, well, if you're asking prosecutors, half of what the defendants do is making crap up, right? I mean, that's what that's what a lot of us think. And a lot of us, watching trials are like, yeah, we don't believe that person, or we do believe it, but a prosecutor still may not. So the point is, a prosecutor saying a defendant's lying is not a good argument because at this point, and that's the whole point of what the defense attorney is making, at this point, everything she says is true. At this point, pre-trial, we are not saying people are lying. We are not saying that she's making up a fictitious situation here. You can't say that. You can't make that argument. So I did think that was a bit of a misstep, but overall, he's making sense with everything she has said. Judge still doesn't get to an overt act.
Case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply. And all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting.
So that right there, you may have missed it if you weren't paying attention earlier, but that right there was a threat here. And it's almost going to be reiterated by the judge in a bit of a reminder. It's more of a warning from the judges, but it's a threat from the prosecutor. So the prosecutor is saying, and you know what, Judge, if you decide that they're allowed to make these statements in opening statements about battered spouse syndrome, and then that evidence doesn't come in because she never testifies to an overt act, and we object to the expert, and if you strike the expert at that point, but they're all allowed to discuss it throughout the entire case, guess what we, the state, is allowed to do in closing argument? We're allowed to say, they wanted to say battered spouse. There was no evidence of anything George Torres did in this case to deserve what Sarah Boone intentionally did to him, because she even admitted on the stand she intentionally did it to him. And it was totally unfounded because he didn't do anything to her. And it's not burden shifting, because normal cases, you can't say the defense didn't do X, Y, or Z, or didn't prove X, Y, or Z, or didn't put on certain evidence. So you can't do that. That's burden shifting. You can never do that to the defense. But if they tell you they're going to put on an affirmative defense that ends up getting struck because they don't put on the right evidence, you can say, this is not self-defense. And that's kind of a threat. Where and we've said it before, if you're going to say it, if you're going to promise something, you better come with the goods. We've said it in lots of trials, and that was a subtle threat there by the prosecutor saying, if you don't bring it, we'll make sure the jury knows. All that mess they were talking in opening statements didn't come out. So can you really believe those arguments? McMuffin said, glad I was able to catch it live. Me and some of the boys were talking about true crime last night. Lawyer, came up in the convo. Keep cooking up great content. Thank you, Mick Muffin. Thank you. I never thought that some of the boys would be sitting around talking about this YouTube page and true crime. That's cool. Louise Pitt, what about no surprises at trial? Yeah, but this means no surprises, meaning, haha, here's a document or a picture you've never seen or heard of. What the defense says, and when we get there, when we get to this bombshell overt act, you're going to realize it would not have been a surprise. We all already know this fact. The state knows the fact. It's been mentioned before. So it's not a surprise. It's just maybe the state didn't see it. Maybe they didn't know the way that the defense was going to argue it. And that's something you don't have to tell them. You don't have to say, I am going to use this email for this purpose to prove X, Y, or Z. You don't have to necessarily do that. If they object to relevance, you talk about how it's relevant, but you don't necessarily have to connect all the dots for everybody based on the evidence that you're giving. Please say he'll go to court when she's on the stand. That is an insight we need. Happy birthday. Thank you. I don't know which day I'm going to be able to go, so we'll see. Dreamcatcher said, these two PDs, they're not public defenders. They're private lawyers working pro bono. Remind me of who you'd find on a phone box advertisement in a desert operating in a little hut. Two divorcees with polytechnic degrees trying to make a buck. Sorry to laugh, but the mic incident. I don't know what you mean by the mic incident. I may have missed that, but I don't think they're doing a bad job. They mentioned again a couple of times, are they crushing it and hitting home runs? No, I'm not going to sit here and say that, but they didn't have long to prep this case, and they mentioned that multiple times, and we're going to talk about that as well when we get to the medical records in a little bit.
But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams rule victim and ask the court to rule prior to trial, hey, if this is how the Williams rule victim testifies and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, can I respond? Judge, trial hearing, ability of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. The state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instruction.
And damages in civil cases.
Are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes,
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
it's not, Judge, but I find myself in the position now to disclose what our view of the overt act is. That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reality.
And he's right. He's right. It is. It's there. Christie said, legally, what counts as an overt act? What is the threshold? So it's kind of like a reasonable person standard. Would a reasonable person be in fear for their life? But lots of times that's a jury question, right? So if the defense presents a scintilla of evidence that this overt act caused them to be in fear, it's up to the jury to determine whether or not that fear was reasonable and their response was reasonable, et cetera, et cetera.
Action of Miss Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, that means I have to tell you, his hand.
All right, here's the overt act. Sorry, I was not paying attention when he said it. So here we go. Here's the overt act.
Action of Miss Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now,
so we have only heard in the past finger or fingers coming out. So now the hand is coming out of the suitcase. That very easily could have just been a slip of the tongue by the defense attorney. Okay. It could still be a hand. Okay. Or a finger or hand, whatever. But it's an interesting slip of the tongue because to me, those details are important. Words, definitions, details are very important because now if it's the hand coming out, let's take out, self-defense for a second. Let's take out reasonable. Let's take all that out. If the entire hand is coming out, that makes Sarah Boone a truth teller in one sense and a liar in another. If his hand is coming out, that means she was telling the truth that she left enough space in the zipper when she originally zipped him up that he could get out of the suitcase. Because the defense attorney just said his hand is sticking out and he could get out of the suitcase. he was getting out of the suitcase. And then she's about to say, or he's about to say, then she hits his hand with a baseball bat. Okay. So that means Sarah Boone was telling the truth about leaving enough space for him to get out. But where is she a liar? Well, it makes her a liar when she said over and over and over again that this was unintentional. This was an accident. I thought he was fine. I thought he could get out. Because if she prevented him from getting out with the baseball bat and either flipped it over or zipped it the rest of the way or locked it in some way or set it up in a way he could not get out, which is then the self-defense argument. You have to do that. You have to intend to keep him trapped in there and not allowed to get out and get you in order to make this self-defense argument. That means a lot of what she said is then not true. If it's just a finger, that adds some weird elements to it. But either way, hand or finger, I do think it makes a difference. But is that enough of an overt act? I don't think Christy thinks so. How is a man trying to save his own life an overt act? She had plenty of time to call for help. If she was scared, he could get out. So we're going to discuss throughout this trial, based on what we find out happened in the past, based on what happened that night, alcohol being involved, and we're going to hear a little more about it when we get to the text messages and the medical records that they're going to discuss in this hearing. But is this overt act going to convince a jury that Sarah Boone was in fear of serious bodily harm or death at the time all of this happened?
Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear.
And he's right. Like if somebody holds up a weapon to you, you don't have to wait to see, oh, I wonder if they're going to pull the trigger before I defend myself. That's correct. But is that the same thing? Does this analogy line up?
Everything else, that means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act.
There were markings on his hand that line up with the bat. I don't remember ever hearing that detail. It seems like a new detail to me. But now George Torres is reaching his hand out of the suitcase. It gets hammered with a bat. So I assume he pulls it back in. I don't know. And also, like when she hits it with a bat, it's hard to just hit somebody's hand, right? It's also hitting his body, his head. What is it hitting? You know, like if his hand is right here and he's reaching it out of the suitcase and she hits his hand, it just opens up a lot of opportunities and things that could be true. That again, this is what I say about trials. We're going to learn a lot as the trial goes on. There's a lot of details we probably don't know. But that's the defense. That's the overt act. Cleanse and Fire said, am I an idiot or is this not self-defense? She's saying that him escaping is an overt act and then she acted to prevent him from escaping. Cleanse and Fire. So I think you bring up kind of the difference between a jury question and a question for the judge at this point. Is it self-defense is going to eventually be a jury question, and the jurors may ask themselves the same exact question you're asking yourself. Am I an idiot? This doesn't feel like a self-defense case. And then if they answer no, it's bad news for Sarah Boone. But at this point, is that a scintilla of evidence that this was self-defense? Everything that the defense is saying is true, and the boxes and pieces get put together the way the defense say is true. Do they get to argue it to a jury? And those are two different standards, right? The jury saying, making this decision, and the judge making the decision at this point. Polytechnic in the 80s and 90s was basically night school, try to gain a degree if you were older, worked in the day. It like used to be online school before online school was so mainstream and so much better like it is now.
It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right. The court has had the opportunity to review the motions, review all the case law.
And now we get the judge's answer.
The state's motion is going to be granted in part and denied in part.
So just by him saying granted in part and denied in part, we don't know what that actually means. What parts are granted, what parts are denied, and now he's going to explain.
With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically...
So he goes pretty quick through this, so I'm going to pause so we can understand each part. Number one, For them to not be able to argue battered spouse at all throughout the trial, to completely strike that defense, denied. State, you lose that argument. Defense is potentially going to be able to argue battered spouse and self-defense. So that's the big ruling. Battered spouse is staying in. But how is he going to limit it?
Wagner, for the reasons identified in the court's prior rulings as to the concept of argument. Again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient.
In cases where you have this, where the defense doesn't testify or the defendant doesn't testify, is because there's other people that testify and explain what they're going to use in the battered spouse defense that the expert's going to use.
Predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established.
So that was the second part. That's the part the state won. No experts can come and testify before the overt act and the factual foundation is laid for the battered spouse syndrome and the self-defense in this case. Duh, right? That's like how it is in every case. So while that may seem like a win for the state, so far, major wins for the defense. JSMP Jen, thank you for changing your name, by the way. Easier for me. Peter, do they know what defense they are using yet? Battered spouse or self-defense? I'm confused. Glad you're safe from Milton. We had a tornado. Wow, glad you're safe too, Jen. So battered spouse is a type of self-defense. So it's self-defense, battered spouse syndrome, because battered spouse syndrome has the domestic relationship, the past issues. You can get into a lot of those past issues if you're proving specifically battered spouse and how it affected the psyche of Sarah Boone and how it may be different from another person based on her prior experiences. That's what the mental health experts are for. Jennifer C. said, wasn't the opening so you can get out? That's what Sarah Boone said. Sophie said, any confident lawyer would be saying that the evidence will support it. So you'd be surprised, right? If there's really no good faith basis or reasonable belief or us to think that some evidence is going to come out support something, lawyers aren't just going to say it is, because that's how you get a bad reputation. That's how you get scolded by the judge and potentially sanctioned. So you really only say it in cases where you really believe that's how the evidence is going to come out.
Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning,
you want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection.
So I'm so glad experienced defense attorneys got up and got the clarification from the judge's order, because so often, especially when you win, you're like, no, judge, that's good. I don't need any clarification. But because the judge made that ruling that no expert can testify, it almost sounded like you can't do anything about battered spouse until Sarah Boone testifies, which it sounded like that's part of what the state was arguing. The judge is like, no, that's not what I'm ruling. You can mention it at opening. You can talk about it in voir dire, which is really important and probably happening right now, that they're talking about battered spouse syndrome with some of these jurors, which is going to be very important. Get their experiences. How many of them are involved in relationships like that, right? You can imagine how important that's going to be. And God forbid, I hope it doesn't become an issue with juror misconduct or somebody not answering or not giving information, or defense lawyers If Owens is watching YouTube, he's seen how defense lawyers may be either not digging in enough or digging in enough to create the issue as the appellate argument. Make sure you ask the questions to every juror, even if they don't raise their hand, even if they do raise their hand, go through individually with every juror and talk about their experiences with battered spouse, because if they lie, that's going to become an issue afterwards. So that's going to be incredibly important. And if you notice the way the judge said it, if you want to mention it in opening, I'll let you mention it in opening. It's almost like a little warning. You mention it, but if there's no overt act and you're not able to get to it later, that's on you. And the state's going to be able to make certain arguments that probably aren't going to make you look great. So that's coming back with a little bit of a warning shot by the judge.
As to, should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same.
All right. So the next one is the statements during the interrogation. We read this. I talked about how a lot of times these are let in because if they say they're just questions that law enforcement officers are making, law enforcement officers' opinions on guilt or innocence or who did what, not usually allowed. But if they're questions that the defense answers, sometimes judges will let them in. But let's hear what the judge said in this case. So the lawyers just kind of made similar arguments to what we already read in the motions, but here is the judge's ruling.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree.
Okay, well, the Jackson case speaks for itself and the court has reviewed it.
Thank you.
All right, thank you both for your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death.
So one thing I would have, so by the way, huge win for the defense. Those comments about you killed him or you're the reason he's dead, those comments made by the officers are not coming in anymore. That's a huge win for the defense that I've seen go both ways in cases. I think the judge made the right decision, by the way. Don't let officers, we know what officers think about most people they arrest, right? And how they would explain it. So that's not really how it's supposed to work. And they're not experts on causation. But one thing I would have argued if I was the state is, judge, the defense is stipulating to cause. The defense is stipulating that Sarah Boone did X, Y, and Z that caused his death. I don't know if they made it. I don't remember them making it now as I listened to it back and read the motion, but the judge is saying cause is still an element they have to prove. I'd be like, judge, that's been stipulated to. But I'm glad the judge made this decision. I think it was the right decision. Another big win for the defense. So far, two major big wins for the defense. Will they end up carrying the day? We'll see. But a very big win for the defense. Cleanse and fire. I feel like the defense is talking themselves into first degree murder because she's saying that she never intended to free him from the suitcase. I agree with you, cleanse and fire. When they go this route, I don't know about first degree, but when they go this route, it's definitely not manslaughter. Definitely worse than that. Now it's kind of an all or nothing play. Jen said, did it just for me. Well, I do appreciate it. I noticed immediately because I try to do this pretty quick. And sometimes I just, read the names and it can get me in trouble. Sometimes I understand yours was kind of a pun, but I appreciate it. There's about another minute of this we're going to listen to.
Court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted and those will need to be redacted from.
Quite a few times the judge accidentally misstated like state when he meant defense or state when he meant judge. So a couple times. So if you hear that, don't get confused. He granted the defense's motion here.
I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling or the court's ruling?
Let me just tell you this. This right here, this specific, because I think Sarah Boone would have been able to get into battered spouse even without a lawyer. Okay. It wouldn't have been done as well. but I do think that she would have been able to get into battered spouse without a lawyer. These are the kinds of motions, no way. And we're going to hear medical records and text messages. There's no way she makes these arguments or wins these arguments. The state just this is what I mean by railroading. Anything that's close or a gray area, if a criminal defense attorney doesn't make a big deal about it or object to it, and the state does it, it just kind of happens. So this could have very easily come in. They could have played the entire interrogation. These statements where law enforcement officers are condemning her and she's not disagreeing with them, you can understand how damning that would be in front of a jury. If she was representing herself, my guess would have been that this all comes out and this is all before a jury. So how different is it that she has competent lawyers? I know people are saying they didn't do a good job or they're not great or it's, the Mutt and Jeff show or whatever. And yes, we've seen better, we've seen worse, but they are making a profound difference from a criminal defendant representing themselves. I will just say, are they going to win? I don't know. That remains to be seen. People are telling me to slow it down every time the judge talks. What speed do you think it is on? Because I would love to hear what speed you think it's on, because I think you'd be surprised. Okay. Next is the medical records. They talk about how George went in for laceration from punching a window. It's 50 pages. Another one was he's the victim of domestic violence. I think his brother beat him up or something. And the state's like, it's all these pages, judge. It's not fair. The defense has to pull out a couple. Only the narrative or certain portions are irrelevant. Seems like an argument, seems reasonable. But then the defense is like, well, judge, they've got blood alcohol content in there. These are important for different reasons. We're going to compare them. What is her psyche? What does she know? What does she explain happens? So more than just those are relevant. And I do sympathize with the defense here being like, judge, we've got hundreds of pages here. We haven't pulled out every individual one, but at this point, we just got on the case and the state gave us hundreds and hundreds of pages we had to go through. So we'll provide this by Friday, which I felt was reasonable. And these are kind of the arguments going back and forth. Let's listen to a little bit of it. Because we're at 1.25 speed, we can listen to a little bit more than if we just listen to it on regular speed. All right. Let's listen to them kind of go back and forth about the medical records.
Down.
Okay, well, what of it needs to be narrowed down since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down.
So he says that's not how this works. It does work like that in front of some judges, and these guys are out-of-towners. But I do think it's reasonable to give them a little bit more time before you just say no. Or you just say it's got to be done right now. Because technically they are providing the medical records. If they're going to be narrowed down, give them a second. The state objected. Now, in normal terms, I would want, if I object, you respond to my objection and tell me what is relevant and why, which it says they're not doing at this point. So we'll have to wait and see.
We'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, George Torres was over a point.
And I'm going to give him grace because, again, if I'm the judge and I'm pushing them and I know they just came on this case, by the way, I don't think the judge feels the same way I do about this. And he's going to make a comment later that's going to let us know what he thinks about how all this has gone down and Sarah Boone and her representation and these lawyers. So just hold on to your seats for that. But I think they're doing the best they can. And frankly, if they want to put the whole medical record in, they should be able to say, I want to put the whole medical record in. And the judge is going to have to look through them and say, okay, these pages aren't relevant. And from my perspective, it's a situation where the defense is kind of doing I don't want to say sloppy, but it's kind of like they're making sure they're preserving everything so that they can kind of narrow it down as they go. They need to start narrowing it down, right? Like I would say maybe by the end of jury selection, you guys have to have this done, which might be the end of the day today, might be tomorrow, but they have a little bit more time to do this. So we'll kind of see where the judge ends up going with this one. But it is frustrating. I get why the judge is frustrated, why the state is frustrating, but I also understand the defense's point of view. So I'm giving everybody, a little grace here in that they're all pushing towards trial. The defense is trying to provide a competent defense, and that takes time. Like I said, a lot of this feels impossible to do in the limited amount of time they had.
0.31 BAC. Every time
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
Have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk, or that's when he does something violent or threatens.
So again, they're going to correlate the drinking with the violence, the drinking with the beating, with the punches. He gets in fights with family members, punches windows. They're going to try to connect all that. So they're saying it's relevant. So I don't think anybody, including the state, is saying these medical records can't come in. They just don't want 50 pages. And I'll tell you, this is just something that's happened to me. And I'm not saying that's what they're doing. But sometimes we've had jurors who lock into this defendant or this person who went to the ER takes this medication. And from our perspective, the medication is not relevant at all. It's nothing to do with the case. There's no experts testifying to how it connects, but somebody's a nurse or a doctor or, somebody on a PA on the jury. And they're like, oh, most people who take this medication are violent, therefore X, Y, and Z. So from my perspective, sometimes maybe the state wants to take out the medication he's taking or something like that. Sometimes it can be certain pages have irrelevant information on maybe tobacco use, and it says, yes, I smoke 5 times a day. That's not relevant. You want to pull that out because there might be somebody on the jury. I'm just telling you this happens. But there might be somebody on the jury who's like, oh, I hate smokers. Or if he smokes 5 times a day, that means he's a bad guy. And it might absolutely be totally irrelevant. Might be totally irrelevant. So there could be certain things like that they want to pull out, and they really do need to do that as the defense. But time is ticking here. Time's ticking.
To do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay. What about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. It's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
Polycare, this is a balanced, level-headed take, right? Like you don't think it is, but let him argue it. And that's where the judge is. It's like he doesn't have to believe that this is self-defense in order to say that it clears the legal bar for them to argue it. Reese's mom, I don't know if they'll specifically talk about how, painful and brutal it is, but I also think it's kind of obvious in this case, right? I mean, there's some cases where everybody's like, whoa. Family account said she controlled George, who struggled with alcohol and low in life. She controls the courtroom, commissaries, etc. When found guilty, it'll feel like victimhood she needs. This is bliss for Sarah. Interesting.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
Yeah, you don't make the arguments after she testifies. You know what she's going to testify to. That's the point of a proffer, right? An offer of proof. You know what the facts are going to be. So you can just tell the judge, this is relevant because of X, Y, and Z. If you want my opinion, right, which I keep saying that, obviously I assume you're here because you want my opinion. They don't know what all these medical records say. They are not prepared to say page 2 through 17 is relevant for this reason, Judge, because the state feels more prepared, which is no surprise. They've been working on this case for years, and the defense just got on it a couple weeks ago. This is a prototypical situation where the defense is just not prepared for everything going on. And it felt impossible when they started this case, knowing the judge wasn't going to give a continuance. It felt impossible to be fully prepared. And we're seeing what that looks like now. I do not think they are prepared to argue these medical records issues. 500 pages.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10, 15% for legal blood, at the time that he was asking for much.
Did you see a 3 something?
And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably
Whoa, 342. I mean,
some conversion, 10, 15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning.
listen, that sounds like a good argument, right? They're attaching jeopardy. So, Judge, we're attaching jeopardy. It's like we're talking about medical records that even you're arguing the important parts are coming in. You're just wanting to pull out the irrelevant pages. Jeopardy attaching does not affect. This is not like battered spouse syndrome, right? This is not something that's like the whole point of the case. It's like you want to pull some of the pages out of the medical records. So I get it. And that's a good argument. And it brings a lot of weight to the argument. But in reality, this is not something that's like going to crush, make or break a case, because you're agreeing that the narratives are coming in. Paralegal, Pip Paralegal said, medical records, paralegal here. The narratives typically all that's relative. I think you mean relevant. Charting is the bulk of the records are irrelevant. I've gone through thousands of pages of records and know this. So yeah, there's tons of irrelevant stuff, but I will say we have had lots of cases where more than just the narrative is relevant, right? The date, the initial complaints are important. When they go through their systems and they say, does your neck hurt? Does your back hurt? Does your throat hurt? Does your chest hurt? Whatever. Every different part they ask and why, that could be relevant. The medication could be relevant that they're on. The treatment plan can be relevant. Again, a lot of this is in injury cases and wrongful death cases, but sometimes it can be relevant in a criminal case as well. So there are definitely parts of the medical record that could be relevant outside the narrative. But the point is, if you're prepared and you know the medical records, you're able to argue this stuff. It just doesn't feel like the defense knows that yet, which kind of takes me to Pebbles' question. Peter, as it mirrors the defense, seem cagey. So yes, there's a cagey element to this, but I think more of it is they're not fully prepared and don't know all the documents like they want to yet. So they're kind of sounding cagey because I don't necessarily know they think they know what all the documents say at this point. Johanna, it doesn't seem like it because she already testified and the defense attorney asked her question. So I think that's how it's probably going to go at trial. Timothy, imperfect self-defense. It kind of feels like imperfect self-defense, but it's not. They're not going with that. Can't go with that here.
Thank you.
Thank you. All right. the court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the
Those are the important things that would affect your trial strategy that you would need to know prior to jeopardy attaching.
December 24, 2017 incident, the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided.
I am going to grant their motion in limine. Sounds good for the state, right? That little word, unless, is truly the victory for the defense. He's going to grant the motion in limine unless, and we'll listen to it. I'll back it up so you can hear it. So imperfect self-defense means you go and you say, it was an unreasonable belief that I was in fear and I took their life unreasonably. So it shouldn't be a first or second degree M. It should be manslaughter, but she's not going for that because she already got offered that and said no.
I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because
that's all the defense wanted. Look at the smirk from Sarah Boone. She realizes she's smart enough. She realizes that's a win for us. If it becomes relevant in our case, we want to put it in. That's all we ever ask for as lawyers. We're not asking for irrelevant things to come in.
At this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me.
Yeah. Bada bing, bada bang. If you're the defense, that's exactly what you want. And it gives you time, right? That's what you need. You need to kick the can down the road a little bit. If you're the defense, that's a big win for them. Janet, what happens if medical records are wrong? I have had many narratives that are incorrect. Janet, oh man, this could be my TED Talk. It is one of the most miserable, annoying, frustrating things as a lawyer where you're like, it's wrong. It's not even right. But then you present it to the jury. I have had medical records not allowed in because they were so bad and obviously wrong that even the judge, even the doctor that I deposed agreed with me. The medical record system they have is so bad, so wrong. A lot of the stuff is wrong in there. So the judge actually didn't let the other side put the medical records in, thank God. But almost every case I have, there are complete incorrect statements and facts in medical records. I hate it. I hate it so much. It's so frustrating. I wish we could do something about it. I don't have enough time to go fully into this, but Janet K., you struck a chord with me. Okay. It's been an hour. I have 2 more parts I want to play. Hopefully you guys can stick around with some overtime for me. Hit that like button for overtime. On my birthday, I absolutely have to be out of here by 4:30. I have a call at 4:30 and 5 o'clock. So we've got a little bit more time. There are 2 more parts I want to play here. The next one gets into the text messages, the phone information. There are text messages. Again, we learned a lot in this hearing about hide and seek. And there are text messages about getting rid of George. Now, what does that mean? We don't know the full context. Does she mean get rid of him as a partner, or does she mean get rid of him like she did? That'll all be up for debate, but we're going to hear them talk about some of those text messages.
Court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr.
By the way, the defense objected to all pictures and videos and text. It was like a blanket objection to everything and all the cell phone data, and you're going to find out why.
Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the time we have carved out is the case in chief timeline. It's a conversation that begins on Christmas 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020 culminates in a text from the owner of the phone saying, "And bless you and all of you too. I'll get capitals rid of him."
All caps, rid of him. Not great. But again, could mean a lot of things.
So that's the
Definitely not great in hindsight for Sarah Boone.
context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, like case in chief and rebuttal, are the ones that are associated in these timeframes. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child. He's
like, yeah, and he actually missed a picture of the kids, I guess, on their reflection or something that the defense points out later. But he's like, I actually went through all my evidence, Judge, that was voluminous and pulled out the irrelevant things, meaning like, I wish the defense would do that too.
Any of the child's friends, there was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as like the relevancy.
So basically he's just saying like, you know, it'll show there aren't pictures of her having bruises and stuff all over. And she makes comments about his family. We're going to put in stuff like that just to kind of build the relevance of what these text messages are. Now, from my perspective, this is annoying and not like, it's kind of a waste of time. I'll save that discussion for when the defense comes up and talks. But I did want you to hear one comment he made that most of you guys tagged me in this already, so this shouldn't be a surprise. But he's handing the judge some case law on how to get this information in and why he should be able to get this data in.
Versus State 246. A very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar.
So I'm gonna back it up one more time. So look at Kranick's face. Look at the judge's face. You can see he smiles when he mentions Professor Earhart. Let me tell you a second about Professor Earhart. Professor Earhart, one of my professors at Florida State. I was on the mock trial team, and every time I got a packet, I was like, yo, Earhart, come on, buddy, let's sit down. He would sit down with me, and I would go through and spitball issues with him. And I'd be like, should I object to this? What should I pick for my motions in limine? Is this a good one? Is that a good one? This guy is the master. He literally writes the book on the evidence code in Florida. But that's not the coolest thing about Professor Earhart. You want to know what the coolest thing about Professor Earhart was? Not only was he my professor, he was also my dad's professor for evidence at Florida State, 40 years or 50 years before, I guess 40 years prior. And he's been at Florida State this entire time. How cool is that? There's actually two. Yetter, who's no longer there, was a professor for my dad and a professor for me as well. And if Kranick went to Florida State, I know he's a Florida State guy. I don't know if it was undergrad or law school, but if he went there for law school, Earhart was there as well. So this lawyer drops a little Earhart bomb, and you'll see Kranick smile.
Professor Earhart from Florida State University would tell us authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital.
And they definitely have enough for authenticity, but we don't need to hear him kind of go through that. I do want to go through, and this is the last part I want to watch. So the judge kind of spars with the defense a little bit on why you just do these blanket objections, what's going on. And you may be surprised, right? Because people aren't going to like this. I agree with the defense here. And this might be part of what the people thought the defense did poorly on, but I agree with them, and I'll explain why as we listen here.
Now, and I'm supposed to say, no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase. We didn't object to those.
It sounds like they actually did, because they said all videos, but now they've put on the record they're not objecting to the suitcase video. So people have been asking, including Whitney, are those videos going to come in? And the defense isn't even objecting to them. So
Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
the suitcase video is listed in in the things that we don't object to.
I don't know that. I have image_0954. I don't know what that is. Image_0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being
The
admitted?
state conceded they need to lay the appropriate foundation.
Well-
Well, part of their argument.
Okay,
So
then
I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
and I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
he is 100% correct. Now, is it the most eloquent or well put together argument? No, not in my opinion. But what he's saying is, Judge, I guarantee you, if I write no objection next to any of these and later I object, the state's going to say, the defense already said they didn't object to these exhibits, Judge. And guess what? In civil cases, it's different than criminal. In civil, like I told you, we go through, we have a spreadsheet, we go through object, don't object. Criminal cases are very different. And Bombadillo said, this part confused me. Isn't he just arguing to do regular objections during the trial like always? Yes. But you'll hear the judge say why he's doing it, why it's different in this case. And the judge kind of steps back a little bit and is like, you're right. Even though he was kind of battling with him because, Judge, I don't know. We just got this case 2 weeks ago. I don't know. I can't possibly say I don't object and waive my right to object. The problem is the defense said they object to everything, which is technically wrong. They should not have said I object to everything. What they should have said is, Judge, at this point, we want to reserve our right to object to anything as the trial goes forward. We are not waiving our objection to any of the exhibits. That's probably what I would have done. I would have just said, Judge, we reserve the right to object to any of these exhibits as the trial goes on. If you're not going to let me do that, Judge, please point me to the rule that says I have to waive my right to object to exhibits pre-trial, because you don't have to do that. You can do it. It's nice. It makes the trial go quicker and smoother. It's easier for the judge. It's easier for the state. It's not necessarily your job as a criminal defense attorney to make life easy on everybody. Civil, very different world. Forbes said, this argument is so incredibly weak. No jury is going to believe this. That could be true. And that's kind of the weird thing to compartmentalize in our brains, especially as lawyers, is that's not the question here. So while I may agree with you, and we'll see how the evidence actually comes out, right? She's presumed innocent right now, just like the last comment said. But that's not the question we're asking right now. The question we're asking right now is what should come in? What can they argue? Not is she going to win or who's going to win, right? So I get where you're saying. I get where a lot of people in the I get where people in the chat are kind of coming from with that and being frustrated. Like, this is so stupid. Why are we even talking about this? There's no way that that the jury's going to find in their favor. And I get that, and that may happen, but it's not the question right now.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list. of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently. Okay. 30 years. I've never had to do this in a criminal case. Okay.
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then you all parachuted in on.
Oh, shoot. I tried to stop it before then. So he said, listen, the only thing we did this for is because Sarah Boone was representing herself. Things are different. We're actually trying to help her, let her understand what the exhibits are, answer her questions. That's really what we were going to do when I set this deadline, because he's right. This is very unusual in criminal cases. This is not exactly how it normally works. The defense attorney's right. But then this is the comment the judge said, which should make you realize, people say I scream sometimes. Sorry, I do scream. Sometimes I get excited, but this should tell you how the judge kind of feels about what happened in the representation in this case.
Deadlines to prevent any ambush or last minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So
then y'all parachuted in on August the 30th. What do you guys take that to mean, right? You guys tell me. Y'all parachuted in on August 30th, and guess what? You didn't ask me to remove this. You didn't ask me why we were doing this. Now, he's right, but the one thing they did ask was, can we please continue the case? Judge is like, absolutely not. Everything stays in place. But theoretically, they could have asked Judge, what is this? This is weird procedure. We don't want to do this. And they didn't. But when he said y'all parachuted in, I was like, whoa, wait a second. I had to back it up and listen to that again.
those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly.
This is the smart judge, right? That like, this didn't go great. This isn't really how it was supposed to be. The defense is right. But the judge is like, yeah, no big deal. Like, of course you can raise these objections later. Didn't really feel like that with this hearing and the motions and how it all kind of went. But he's like, yeah, duh, of course you can object to these during trial. Great save by the judge. No skin off his neck, nose, back. I don't know what part of the body that saying goes with, but from my perspective, he did the right thing. He corrected it. No issue, not going to be an issue. They're going to be able to object like we always can at the end or during the trial.
But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand.
And he's right. They absolutely would have said, you didn't object to this. You can't object to it now. Now, I will say, even when that happens, sometimes it's like, well, judge, then let me at least make my record because this is totally inappropriate. It's irrelevant. It's not authentic, whatever. If you have a legitimate objection, even if you haven't done this, hopefully judges in the interest of justice would still not allow it. They would grant your objection. They would allow your objection, sustain it, and not allow that evidence to come in.
Any clarifications or questions with regard to the court's ruling?
I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or.
Yeah, but I mean, guess what? It takes time to pull out exhibits you thought were going to come in, but they don't come in because the other side wins an objection.
Black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial. What more information?
This is an annoying argument from my perspective because it's like, dude, if an exhibit doesn't come in because I object to it and the judge sustains it, you're going to have to pull it out, whether it's during trial or now. And we don't know all the relevance or what's going to come out in trial yet. So, I mean, this is not a real argument, in my opinion.
They're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Ms. Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Janella Wadden. And then Janella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah.
And she'll be able to get all that in. But that was the majority of what I wanted in. And the judge did give the defense what they wanted, basically, and said, you can object to this during the trial, like we do in every trial. All right. So we got through it and we're pushing through. Opening statements coming soon. I will be in Orlando at some point. I don't want to have any negative effects on the trial, so we're not going to do that. I would love to say hi to anybody that comes up there and shake hands and say what's up and stuff. In the courtroom, though, obviously, we're going to be respectful and not affect any of it. I don't even know if I'm going to be able to get into the courtroom, right, based on my schedule. I don't know when I can get there, when I could not. That would stink if I couldn't, but we'll figure it out. Stuart said, got my first law school acceptance. Thanks, Peter, for your motivating influence throughout the admissions process. Stuart, keep me updated on your journey. I can't wait to hear where you go and how it goes for you. I love it. K.L. Burke said you cut him off saying blah-de-da. Yeah, I mean, he's right. Somebody's going to be able to come in and authenticate this stuff. But all right, I've got to go. Kim said there's only 3,000 likes. Let's get this video to 10,000 likes. Everybody, please hit that like button if you haven't already for my birthday. That's the present you can give me. And make sure you subscribe to our channel. We're not going to stop on this case. I am fully in, but we got to go. So until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.